This is Senate Judiciary on April 12th, 2022, not 1922. It is, unfortunately, Senator Bruce's unable to be with us this morning. His father-in-law passed away in Sweden, and Senator Baruth is tending to things at home this morning. So our condolences to he and his family. So we're taking up first an issue that's in H740, which is the big bill or the budget bill. And it has to do with Restorative Justice Working Group. And Ben, you wrote it, and we're going to have you as the first witness to kind of let us know why. And I guess my first question is why this couldn't be done by the Justice Oversight Committee. So that's what I would be looking at. It sounds like the goals are admirable, but starting anew.
Sure. Well, Ben Overdrowski for the Office of Legislative Counsel. Senator Sears, I think that's a good question. To give you the committee a little background of how this came to be and how it's in its current form. This was initially a request submitted by Representatives Coffey and Morrissey on basically to look at community justice centers, how they've evolved over time, and how basically they can be assessed to make them more effective, coordinated in all things from services to funding, and how they can best serve Vermonters. There was coordination by Representative Squirrel on the Appropriations Committee to I think find a vehicle for this. This came through sort of a research request first that turned into the language that you now see. There was coordination with members from representatives from the Department of Corrections, the AG's office, DCF, to ensure that their concerns made it into the working group language. And if the committee wants, I can kind of give an overview of what community justice centers are, what they do, and how the DOC, the AG's office, and DCF are all involved before I get into the language of the bill.
I think we're fairly familiar with it, Ben. I appreciate the offer, but I think the members of this committee have been well versed in restorative justice and the history of it. So unless somebody really needs to go over the community justice centers, I don't think it's necessary.
I'm fine, thank you.
Okay. Well, with that, I'll get into the language that's in section E203 of the big bill. The section's entitled Restorative Justice Working Group Report. Under subsection A, the Restorative Justice Working Group is created to evaluate the organization of Vermont's criminal justice system concerning restorative justice programming and services generally, with a focus on the administration and funding of pretrial services, court diversion programs, and community justice center services. The working group will be composed of 9 members, including a local representative from a community justice center that's funded by the DOC, whom is to be selected by the directors of Vermont Community Justice Centers. The intent behind this selection is to ensure that someone who is sort of a boots on the ground director is representative on amongst the membership. Another member will be a county level representative from court diversion and pretrial services or affiliated restorative justice program funded by the AG's office, who would be selected from Vermont Association of Court Diversion and Pretrial Services, another, for lack of a better term, boots on the ground individual. Another member would be a district level representative from a BARGE program or a balanced restorative justice program that would be funded by, who's funded by DCF and who would be selected by the directors of the barge program providers. There would be a representative from the Department of State's Attorneys and Sheriffs, the Chief Superior Judge of the Vermont Superior Court or designee, Commissioner of Corrections, the Vermont Attorney General, the Vermont Defender General, and the Commissioner of VCF. The group would study the roles, relationships, and funding of the various entities providing restorative justice programming. Their work is comprehensive in the sense that it's supposed to identify disparities between the rules, policies, procedures, and administration of restorative justice programming in various areas of the state. They would be tasked with evaluating such programming to ensure geographic equity and equal access and adequate resources. There would be a review and recommendation of any changes to ensure streamlined administration of restorative programming and services, and what that would look like if there would need to be coordination or greater coordination amongst DOC, AG, the AG's office, and VCF, and any other entity that may contract with the state. There would be a recommendation to any changes to ensure a coherent statutory framework. There also, they'd work to ensure that any proposed changes would still enhance the restorative justice goals and principles. And the working group would have the administrative, technical, and legal assistance of all three agencies. And that they shall also coordinate and assist in writing of any reports that the working group may produce. And they also may solicit input and participation from others in furtherance of the working group's purpose. The working group should produce a report on or before January 15th, 2023, which would go to the House Committees on Corrections on Institutions, on Judiciary and Appropriations, and the Senate Committee on Institutions, Judiciary and Appropriations, with any findings and recommendations for legislative action. Meetings shall occur on or after July 1st, 2022. The Chief Superior Judge shall call the first meeting of whoever he designates. The working group shall select a chair. They have discretion to meet a sufficient number of times to fulfill their duties and issue a timely report. And the rest are quorum and voting and attendance provisions. And the working group shall cease to exist on February 15th, 2023. There's sort of a tail after the report is filed in case there's any cleanup that would need to happen, for lack of a better term, or any other issues that the working group may need to confront after the report is issued.
No, well. Is this needed? Apparently somebody thought so. Somebody wants to be.
Start with Willa Farrell, and I think the question, I have two questions. Senator Nitka just asked the first one, which is it needed? And the second one is, why couldn't Justice Oversight do it? I haven't seen much in the way of Justice Oversight responsibilities in this year's bills. So seems to me they're the ideal group to study this and work with all the players to accomplish what the goals are of this. So unless all of you need more work.
Fine.
Good morning, Senator Sears. Would you like me to, sorry, silencing my phone there.
Do you have any problems with the proposal first? And secondly, are there things that should be added to the proposal? And third, could this be done by Justice Oversight, in your opinion?
Right. Well, thank you, Senator Sears. I appreciate the opportunity to provide input. I did give information to House Corrections and institutions, but I didn't have the opportunity to give any feedback on the working group charge. I think we're, I'd be happy to provide more information, work with Justice Oversight or other groups as you designate, but I really would I think it's important to clarify the language so that whatever group is doing its work can make good use of its time. As the charge is written now, I feel that we'd end up spending a fair amount of time talking about what is really being asked of us to do. And so I think I'll just point out a few phrases in the current charge that leave me somewhat confused. There's a reference to evaluating the organization concerning restorative justice programming and services, reference to disparities or variation between rules, policies, procedures, practices, results, coherent statutory framework for all restorative justice programming. So the first thing that when I read these phrases that comes to me is wanting to say restorative justice is not a program. It's an approach, it's a set of principles, and the services that the AG's office funds, that DOC funds, that DCF funds are varied and diverse. They draw on restorative justice work, but they are very different. They happen at different age groups, at different points in the criminal and youth justice system. And there are going to be differences in policies and practices. The results will be different. One can't really compare the outcome of a diversion case to the support provided through a COSA, for example, to somebody returning to the community after incarceration. The charge notes a focus on the administration and funding, ensure streamlined programming and services, questions whether there are adequate resources. It's not clear to me if legislators are concerned about duplication of services or the structure of the organizations doing the work. I will note, as it relates to resources, that in the Attorney General's office, we are working with our fiscal director and community providers to do we're calling it a deep dive into the funding. Given our declining fee revenue, what does it really take to offer these services so that we can bring that information to the appropriations committees? In the charge as it's written now, there's a reference to evaluating a system that ensures equal access and geographic equity. First, I would note that the programming supported by the AG's office and the Agency of Human Services, those services are statewide and available in all counties. People access these programs because they are referred to them, either by law enforcement, a prosecutor, a judge, probation, and parole. So the word access, I'm not sure what is behind, what question we're being asked to address in that phrase. So when I step back and look at the charge, Senator Sears, I really just feel like we need more clarity about what are the questions the legislature wants to address. Be happy to be part of a group that tackles that, whether it's through justice oversight. I am concerned that whatever meeting we have, wherever format this happens, that we're clear about what is the task at hand, so that we make the best use of our time. I hope I addressed your question.
I think you did. I have the feeling that when I was first in the Senate 30 years ago, a man named Francis Horrigan was the state senator from Franklin County, and he was full of very artfully phrased words. And I can remember one time, and it just struck me as so true. He was asked a question on the floor of the Senate about a particular bill, and he said, "I didn't load this wheelbarrow, I'm just pushing it." And so I kind of feel that way right now. I didn't load this wheelbarrow, I'm just pushing it. And so it's clear to me, we've had a lot of discussions in both judiciary committees and in institutions and corrections and other places about equal access to justice. And it starts with the state's attorney or law enforcement and their use of the diversion programs. And I think that's probably the better question regarding access, because there are 14 different state's attorneys, 14 different uh, uh, judges who deal with on any given day on criminal matters. I know they all do, but there seem to be regional differences between, for example, Chittenden County and Windham County, and what's deferred, what's not deferred, what's dismissed, what goes to diversion. And in many counties, law enforcement directly refers people to restorative justice programs. In other counties, they don't. So, for me, what would be most interesting to find out is what do we have, how's it funded, and what are those services that are different from county to county.
There are a few documents I'd be happy to forward to the committee that lay out by county what services are.
I gotta make recommendations today or tomorrow. The bill is moving in the Senate Appropriations Committee, so.
Yeah.
I know the documentation is there, but your points are well taken, to me anyway. For example, Bennington doesn't have the same form of, we have a very wonderful community justice center that does all kinds of great things, but we don't necessarily have the same services or views as Chittenden County. And I don't know if that's good or bad.
Well, and I think one reason for the difference that may be provided by Letha's organization and say an organization in Lamoille County are other funding sources. So I know that Letha obtains grants from other private foundations and other parts of state government. But I think it's fair to say that the work funded by the Attorney General's office and the Department of Corrections Community Justice Center grants and the DCF's barge grant, those are all available in all communities. It's out there, but many of the organizations out there do other work, which is really important, and have found other ways to fund that.
So, any other questions for Willa? Thank you very much, Willa. Appreciate it.
Thank you.
Thank you.
The next witness is Matt Valerio, Defender General, if he's here. Hi, Matt. Good morning.
I really don't have much to say about this. I didn't actually know what was going on in the House, and it was brought to my attention when your committee asked me to come and talk about it. We're willing to do whatever is asked of us. I'll put somebody on it and we'll deal with it. I was unaware of any big issues regarding community justice, but like many of the things in government, it is often a good idea to take a look at it periodically. And I have no, qualms about it being in the Joint Justice Oversight Committee or as a separate committee. I really don't have any strong feelings about it either way, but of course we're willing to participate in whatever way the committee and the legislature would like us to.
Thank you. Any questions for Matt? All right. Next is Al Cormier, Chief of Operations, Department of Corrections.
Good morning.
Welcome, Al.
Thank you. Good morning, Senator. So from the DOC perspective, initially we were not consulted on the language. The lack of clarity piece that Willa spoke to, that's a concern for us as well, and not being part of that. As the language is written, we don't support it. And we believe that this working group would put a huge burden on the DOC and DCF, and Commissioner Brown can certainly speak to that, but we're already working to achieve the objectives of this group and believe that this would really detract from the work that is already ongoing. As configured and written right now, the working group really does underrepresent a lot of the key partners, specifically the CJCs. We're currently working with all CJCs, and this limits it to one representative to represent everybody. That's going to take away from the process, and I think the ultimate goal that is in play here. We do plan to work with the CJCs after this legislative session to map out future restorative justice work. I think this work would be duplicative and again take away from the work that's already underway. You said it at the beginning of the testimony. You're very familiar with the CJCs. We're willing to testify on any updates or progress within the program at any time with any of the committees. The AG's office, DCF, and ourselves already work together very closely with these matters. So again, as written, we are not in support of this time.
Senator Sears?
Yes.
I think I must have missed something at the very beginning. I don't know where my head was. Where did this come from and why did it come?
It came according to testimony from alleged counsel. It came from the Senate.
Came from the Senate?
No.
I think you froze.
Institutions, and working with House appropriations, they put it into the big bill. It was originally Representative Morrissey and Representative Coffey that did it. Representative Morrissey's a board member of our local community justice center, and that may be why. I don't.
All right, so can I ask a follow-up question given Willis? Oh, I think you're frozen.
Texting.
I'm frozen, or
You're unfrozen now, but given that, can I ask
Yeah.
another question?
absolutely.
So it
Of
seems
whom?
to me that one of the things that they're looking at is kind of standardizing and kind of making the structures the same and standardizing the services and the processes statewide so that everybody gets the same. But that flies in the face, I believe, of what Willis said, is that many of them, given the needs of their communities, are involved in other things. And so setting a defined structure would be limiting and inhibiting for them. Did I get that right?
Yes.
Okay. So I
my-
don't want this.
I'm gonna, given that Matt and the position of Department of Corrections not supporting it, I think it is a concern. Matt didn't know about it, but's willing to work with them. And Willa has concerns about the definitions and what it all means. I think she makes a good point. Restorative justice is a set of principles, not necessarily a program. And it's using the principles of a restorative justice that goes back to the first one I remember doing it, and I'm probably giving credit to somebody who picked it up from somewhere else, but that was John Gorchak when he was Commissioner of Corrections, started that, but it really started with Native American tribes who would, rather than incarcerating somebody or doing whatever else, would have meetings with the elders and mete out some form of restorative justice. For example, you're going to replace the horse you stole or whatever, pony or whatever. And I can remember hearing from some of those folks way back in my early years in the Senate. So Will is correct. It is a set of principles, not necessarily a set of programs. Programs are designed around the restorative justice principles, but may not necessarily be the same district to district. So are there any other questions of Al? Mr. Cormier, excuse me. I don't know if Derek, are you with us, or you're listed on the list of witnesses, but I don't know if you have anything to add to Chief of Operations Cormier.
Good morning, Senator Sears and the committee. For the record, this is Derek Mio-Defnick, Community and Restorative Justice Executive with the Vermont Department of Corrections. I would echo Willa's earlier comments about the need for much more refined clarity of charge were a group to ultimately be teed up to be effective and successful in its charge. And to Chief of Operation Cormier's point, we are indeed internally with our community justice partners engaging in a process of projecting out and looking at the next evolutionary step in the way that the Department of Corrections utilizes the legislatively appropriated funds that are in our control, through which we grant out for restorative justice services. I do think that the principles of restorative justice, as discussed in this meeting this morning, really place an emphasis on communities designing responses consistent with a set of overarching principles. And I think it's incredible work, by the way, that's happening around the state, and that we should all be remarkably grateful and proud of it. But beyond that, Senator, I don't think I have any particulars to add on to the comments as made by my department and through the Attorney General's office. Thank you.
Thank you. Sean Brown, Commissioner, Department of Children and Families. Good morning, Commissioner.
Everyone. Good morning, everyone. It's good to see the committee today and others. Similar to the Department of Corrections, we don't support the language in the big bill. We weren't consulted and were surprised when we saw it in the House version when it came over to the Senate. You know, it does lack a lot of clarity. We trying to understand what problem it's trying to solve. And as this committee is well, we spent a lot of time with Senate Judiciary this fall on S-224, which raise the age of bringing 19-year-olds in and make some changes to youthful offender and raise the age, but then also asked the department to do an additional study regarding secure facilities for, emerging adults. And so I'm concerned that we won't have anyone available to help push the wheelbarrow if needed at this point. The team that would be involved in this has a lot on its plate. And so I'm concerned that we would be able to play a role in this work group of any, depending on the contribution level. And also, we participate in a couple different work groups. There's the juvenile jurisdiction reform work group, and then there's also, the juvenile jurisdiction stakeholder group, and then the juvenile justice reform work group. Where all, these were the matters that we would talk about, and so we're happy in those forums to have a conversation or in the joint justice oversight work, but really feel like the creation of a new work group is really duplicative at this point, and I'll end there.
Okay, thank you. Any questions for Commissioner Brown?
I just have one. On page 2, 3, it says the district level representative from a balanced and restorative justice program provider currently funded by the Vermont Department of Children and Families director. Who are those directors? Is that like the directors of the regional offices around the state? I don't quite understand who that person is.
That's a great question, because that's one of the questions I have as well, is not understanding the intent of that language as it's drafted.
Yeah, I'm just going to ask Ben, do you know who that is?
Sure, and you're talking about under B3.
Yes.
So what these three, what B1, 2, and 3 were, the attempt was to capture so that one of the, so it was a district level representative, so talking about 3 itself, a district level, that's language sourced from DCF. And it would be someone that would be selected by the other district directors. The intent of the sponsors was to ensure that those directors or those leaders of those various centers or administrators were represented in the membership. And this was an attempt to essentially make sure that those representatives were selected from their peers to the working group. And so that's what 1, 2, and 3 are aimed at capturing there.
Okay, thank you. Thank you.
Any other questions for Commissioner Brown? All right, why don't we go to Judge Zone?
Good
Are you
morning.
open, sir?
We are open for business today. Absolutely. Yeah. So, good morning, Tom Zone, Chief Superior Judge. I agree with everything Matt Valerio said. We weren't consulted. I'll be willing to do whatever it takes in order to make this work if the legislature determines this is an appropriate way to go. And it certainly appears as though this may be something that would fit squarely within joint justice oversight. The only thing I would add is what was just being discussed as far as the selection of the groups. It seems to be, I understand the idea of trying to have groups selected by their peers. My quick research indicates that there may be 12 different barge programs funded by DCF. And so it would seem that we have to then go to those programs and say, you have to now vote on somebody who you want to go forward to be your representative. I think there are 18 community justice centers. So DOC, we'd have to go and get, I think they're all funded somehow by DOC. So we'd have to go and have 18 groups get together to decide on who it's going to be. And I don't know how many people or how many groups are involved in the Association of Court Diversion and Pretrial Services. My suggestion would be, I know it goes a little against the intent, it might just be a lot more streamlined and make a lot more sense to say that under B1, the representative is selected by the Vermont Department of Corrections representative on this board, that under B2, the representative is selected by the Attorney General or his designee. And on number 3, that the representative from the barge groups is chosen by the commissioner of DCF or designee. It seems to me it avoids adding a lot of steps that may not be necessary to effectuate the membership.
I'm amazed that this got into the budget without consultation with people that are involved, from yourself to Commissioner Brown, Department of Corrections, Defender General. It just seems to be. So I think the biggest problem that these groups face, and been working with the Network Against Domestic Assault and domestic violence and sexual assault. I've been working with in part of my budget process with other groups who are relying on, and Judge, maybe you can help me with this, relying on surcharges and fines for funding and are unable to meet their budget goals and are constantly behind the 8 ball. My information from the Center for Crime Victim Services is that fines are down about 40% from what they were pre-pandemic. And that's revenue that they're losing. Even surcharges are down. So, I mean, I think if I were going to recommend anything for justice oversight to look at, it would be, I look at number 3 on C3 on page 2, and I would change it to review and recommend any changes to ensure proper for programming and services mechanisms of the Department of Corrections, Office of Attorney General, Department of Children and Families, and other entities that administer restorative justice programming and services in the state. And that is the real problem most folks are facing. And that is truly a budgetary issue. And I would add the Center for Crime Victim Services. Our victims advocates are down about $2 million. And then there's the loss of some federal funds through the Violence Against Women's Act. And so somebody should be looking at both what we expect for funding and so forth. And we've danced around this issue for quite a while. So I don't know what the committee thinks, but it seems to me that we either take the whole section out of the budget and recommend to appropriations not to even do it, or we ask Justice Oversight to take, with the help of the Joint Fiscal Committee, to take a look at funding sources for all of these justice-related programs.
I would take it all out.
Me too.
Me too.
Well, that's 3-1. So I guess we recommend that we take it all out.
And then do the thing with justice oversight.
You can put something in the budget to ask Justice Oversight to look at, but take this out, but then ask Justice Oversight to look at some funding, permanent funding streams.
Yeah, well, we've been doing that and we haven't been successful, but maybe if we put Justice Oversight on it, looking at the loss there was just a fiscal note, Ben, prepared by Dan Dickinson, and I think you gave us a copy of it. Had to do with the loss of funds and so forth. I think Justice Oversight should evaluate that.
But that's a separate issue than this amendment, this bill.
Yeah. Yeah.
Yeah.
Well,
Well,
it
I
would
will
take the
take
place
that.
of this.
Yeah.
I gotta find that. Remember that document, Alice? We got it in, I think, in a profs, or did we get it here?
Tell me a little bit more about it.
Yeah, it was by Dan Dickinson.
Oh, yeah, did we get it just recently?
Yeah, it was a pretty thick thing, and I've got it in my desk in Montpelier.
I have it in approach. I think I have it in the approach.
I think this is it right here.
Oh, here it is right here.
Yeah. Ben, could we incorporate that and make up a paragraph to replace this?
Here. Pretty big item.
Don't put the whole thing in.
Yeah, I'm happy to work it in replacement. I would need some time to review and craft the appropriate language, but that should be workable.
Okay. Is that the feeling of the entire committee?
Yes.
Yes.
Yeah, unfortunately, I don't have that document with me,
There
but
it
we
is.
have looked at it. And I think there are so many agencies, and it has to do with how we're, with our justice reinvestment monies and how they should be spent. I know portions of it are going to domestic violence programming for offenders. Portions are going to Derek's program for housing for offenders coming out, and a couple of other programs. So combining that number in with the problems that those folks are facing. Any comments from anybody who's in the audience who would like to comment, Willa or anyone else on this? Okay.
And Wanda and group are here. They're out in the hall. Wanda Manoli.
Oh, good. I'd love to. Well, since 2 committee members are missing, that gives us extra room in the committee room. Yeah, we have the 11 o'clock thing. Is Michelle there, or is she on remotely?
Not yet. It's still a little before 11.
Oh, okay. Well, why don't we Do you need anything else from us, Ben?
I don't think so. I mean, I may just revisit once I have a chance to review the fiscal note. I may circle back around with the committee just to kind of get a better understanding exactly what's being looked for, given what's in the note. You know, the other thing I think just might be good for context about sort of the impetus for all of this is it was really based on what was discussed at House Corrections, is that there might be these disparities between statutes that govern DOC, the AG's office, and the DCF, that where there may be just a lack of coordination and sort of you know, again, that's concern for streamlining and making sure that when people look at a community justice center, they sort of know what they're getting, because there's oftentimes a misnomer between the facility itself and the programs that are administered through a community justice center. And so there was discussion in the House just about a review to make sure that there aren't those disparities, that there isn't duplication, and that there's sort of a centralized understanding of what is being provided at a community justice center. So I think that was this.
Well, you know, it'll go to conference and they can suggest changes, I suppose. But our focus is on how do we maintain funding for these programs in light of significant loss of funding that they look at. And then also there is the issue of cannabis sales, and 30% of that goes to after school programs of the sales tax.
No. 30% goes to prevention education, 6% sales tax goes to after school programs. 30% of the 14 excise tax goes to right off the top to prevention education.
Yeah, well, right. But the money that goes from the sales tax to after school programs, what I was about to finish with was that the Bennington Community Justice Center is providing after school programming already. So, you know, that coordination of funding and so forth would be helpful. Anyway, why don't we let the witnesses in on the secondary enforcement of minor traffic offenses?
Michelle's on her way.
Okay.
Campbell retired.
Very much, Ben.
I just found
My pleasure. And I'll follow up once I get a chance to review the fiscal note.
you could read them all, but read that one about tree. Wanda?
Just work out. They need to,
They all have it.
they don't, they do.
I just.
Yeah,
they are. We're live, just so you guys will know, when Campbell retired.
Take care, please.
Bye, Ben. Bye, Ben.
Hello, so Peggy, we're live. We're on.
Yep.
Good morning, Senator Cedars.
Good morning.
Jill.
Feels like afternoon already.
What is this minor traffic offenses?
I have an amendment.
Minor traffic?
Yes, we are taking up H 635 as passed by the House. So let me know when you guys are ready.
Okay.
Senator Sears, should I start?
Yep, please go right ahead. It's
Okay.
H65, correct?
Yes, correct. So we're taking up the version that's passed by the House. You'll see it's pretty straightforward. It is a requirement that the executive director of racial equity, the commissioner of motor vehicles, and the commissioner of public safety are to jointly look at motor vehicle violations for the purpose of making annual recommendations to a few committees. with regard to whether or not the statute should be repealed, modified, or limited to secondary enforcement. And then you'll see in subsection A, there's a list of motor vehicle offenses that are the first ones that they're supposed to take a look at. And then moving on to page 2, you'll see subsection B is that the executive director and the commissioners are to jointly report the recommendations to the House and Senate committees on judiciary, on government operations, and on transportation, and to do that the first time by October 1st of this year, and then annually thereafter. There's the standard 5-year repeal or sunset in section 2, and the act is to take effect on passage.
All right. And so what this committee is going to do, or what these people are going to do, is look at these various these various traffic laws and recommend whether they should be repealed or whatever. Is that what I'm?
Correct. The bill as introduced was focused on these particular offenses, but looking at designating them for secondary enforcement, the way that you have currently the seatbelt law, and it was modeled after some legislation and laws in other states, and House Government Operations took it up, and then they turned this into a study and an annual reporting requirement instead.
An annual reporting requirement?
Yes.
Every year for 5 years.
For 5 years. Yep. So the idea being that they start with these designated ones in subsection A, but that they could move on and look at other motor vehicles as well.
So there's can I ask a question?
Absolutely.
So with regard to, maybe you can just tell me, Michelle, what this means in terms of number 8 at the top of page 2.
Sorry.
Yeah, no, go ahead. Yeah.
Turn my sound off.
This one about possession of consumption of alcohol or cannabis.
So this is one of the civil motor
Possession
vehicle.
of,
No possession or.
it says, second.
Possession or consumption of alcohol or cannabis. So these are the open container laws that you have in
Oh,
Title
yeah. Oh, that's
23,
what I was
and then you amended that when you did legalization of cannabis
Okay, well-
a few years ago. So this is that particular offense
Oh,
that
okay.
provides for a civil penalty, a traffic ticket, if you have an open container of
This,
alcohol or cannabis or
The
somebody's
ones-
consuming.
I looked at this and the second one says possession of consumption. So, all right, that's supposed to be all,
Yeah.
no problem. But does this mean consumption of alcohol by a driver, by the operator? The first one, consumption of alcohol by the operator. How does this one work? What is the amount in that one? Do you know? The first one?
What is the
In
amount
other
of?
words, does this 0.08, is that what this says? Is this?
No, this has nothing to do with this is not DUI. That's a separate. This is that if you are found to have an open container of either alcohol or cannabis in your vehicle in the passenger area, or someone consumed, that is separate and apart from a 1201 violation of Title 23 for being under the influence of drugs or alcohol.
Doesn't this seem to say possession or consumption of alcohol or cannabis by the operator? Doesn't, isn't
These
it?
are separate. I'm just saying that these are separate offenses in Title 23. They're not, it isn't DUI. DUI,
What-
it's having to prove blood
I think
alcohol
we're-
and the underlying
Hold-
offenses.
Can I just think what you're missing the point is this is a report on whether or not the statutes listed here in the first report should be repealed, modified, or limited to secondary enforcement like seatbelts. That's what the question is, right? So it
just
isn't-
says
It isn't doing anything about those. It's just looking at them.
Yes, I understand that, but I'm just wondering, is it to look at consumption of alcohol by the operator? That's what this seems to say.
That you're driving home and you've got a can of beer.
You've got a beer.
You've got a beer, you're not even drinking it. You
Should
just
that
got
This
a beer.
says consumption.
Well,
Well, that's what the statute is. It's an open container law but also covers consumption. And so the idea is that the folks in that group would take a look at that and say, would they make a recommendation to you that no changes at all with regard to enforcement? Should it be secondary enforcement if they see someone with a can of beer? Should it be, so
I see that if it's about an open container, but this actually says consumption. So I'm wondering, are they looking at, I'm wondering, what was this one up to what amount if you were?
The amount doesn't matter. It's that.
Are they looking at if you're having a beer and you're drinking it in your car?
If they see you sip a beer.
Yeah.
That's consumption. That's a separate violation from, are you intoxicated by drugs or alcohol?
My reaction, can I just, my reaction to this is we should take number 8 out.
So this is an aside, but you might not find it amusing, but I always did. My daughter lives in Montana, and when you ask somebody, how far is it from someplace to someplace, they say 3 beers, 4 beers.
I think just taking number 8 out is the simplest. It avoids that issue.
I think if we're going to look at it, it seems to me that having this should be looked at, because having a passenger having an open bottle, it should not be a crime.
But it says well, I'm talking about.
It also says by passenger. There's 3 different sections there. They should look at all 3 of them.
Okay.
Take out the operator one.
All right, take out the operator. 1134. Anything else you want? I'm
not going to say take it out, but that was quite a big deal when they passed the one about using tobacco in a motor vehicle with a child present. Now, maybe that should be looked at, but.
Senator Sears, Mike Sherling has his hand up.
Yep, Mr. Sherling.
Oh, there's his hand, huh?
Thanks, Senator. I don't mean to interrupt committee discussion, but we may have a path forward for you that simplifies a lot of the nuances here. For the record, Mike Sherling, Commissioner of Public Safety, and I think the administration's pretty well aligned that we're in support of taking a comprehensive look at Title 23 and all the motor vehicle statutes, and would simply suggest that rather than having a specific list and rather than having a repetitive report, that you edit this to simply direct us to take a comprehensive look at Title 23 and determine or recommend what should be primary, secondary, or deleted from the title, and do that once and report back on a slightly elongated timeline, not October of this year, but maybe midwinter, January-ish of 23, and report back to the General Assembly at that point.
Okay. Very good. Thank you.
So
Actually, I like that suggestion.
Can I ask a question about that? I mean, I like that suggestion too, but I'm looking at this and I always thought that there's nothing on here about carrying your driver's license. Do you have to carry your driver's license with me? I've always been under the assumption that you didn't have to, and I hardly ever do.
You do technically,
24 hours.
Senator, that and your registration certificate. However, in our testimony to the House, we observed that that's something that we could contemplate removing as a penalty offense, because it's all electronic now. So it's good to have your ID with you, and we certainly would suggest that, but is it worthy of a fine at this point in the evolution of technology? I think we will probably recommend to you, without prejudging the process, that those things could probably be eliminated, or make them a requirement though without a penalty or something along those lines.
All right, thank you.
I like the suggestion, but I'd hate to leave without hearing from Wanda Manoli, because it's so rare that we hear from Wanda in this committee.
Good morning, committee. It's a pleasure to be with you today. So you can hear from me, Senator, but, working with Commissioner Sherling and with Susanna, we're bringing forth this recommendation to be able to look at all of it and come back to you, our recommendations where we might want to amend, repeal, or secondary. I absolutely agree. This is a worthy cause. It also is going to take some work to look at these statutes. So extending it out to January is our preference. And in addition, we do not believe it needs to be a reoccurring report, because if we look at the language as is, we would look at those statutes and then we will be done. And I think going forward, being able to bring forward recommendations and to have a good conversation with the legislature, around certain statutes will benefit all.
Well, it's nice to see you here. I'm assuming that is your, the person who's going to be doing most of the work next year.
So thank you, Senator, and I apologize for not introducing Director Fakos. And I think many of you probably know Tony from his career as a police officer in Montpelier and the chief of Montpelier. And I hired Tony to come in and to work with me as the director of our enforcement unit to move forward, change and to look at these objectives very broadly. So it's been a pleasure having him on my team.
Well, I'm glad to see him here in a different role. He was frequently a visitor to this committee as chief of police of the city of Montpelier. When we needed something on an emergency basis and didn't have time to get somebody else, he always volunteered to come over.
I recognize you.
So, I just want everyone to know I still use him on an emergency basis, and he's always saving me for different reasons. But it's been a great opportunity.
Nice.
So
I wanted, can I just remind the two of you that I'm not sure if you're happy about it or not happy about it, but in the Agency of Public Safety, you were put into the study along with the other law enforcement in the state instead of moved.
I think it's appropriate for us to be a part of the study and the discussion, and to look at the, the organization of, the Department of Motor Vehicle. And so it was appropriate, and we absolutely understand.
Okay.
Have you talked with the director of racial equity on this, and are all three of you in agreement?
We did communicate via email yesterday, Senator, and I believe we are, she may be on.
I don't have her on my list. That's why I wondered. I have
Okay.
Judge Zone.
I'm comfortable in relaying that. I think she's amenable to the direction that we've described, and I'll just double check that. And if there's an issue, I'll let you know, or I'll have to reach out.
I think that's a much simpler method, and then we don't have to argue about which crimes are on this list. Because I was wondering about all the pedestrian things, particularly in the light of what happened to Dwayne Haskins, the quarterback for the Pittsburgh Steelers, on a busy interstate getting hit by a truck, killed this week.
Senator Sears, if I could just make an observation. If we go that direction, it nullifies my request to add another provision here. But I'm glad to see Tony Fakos is now spear pointing this discussion, because Tony, I'm really hoping you take a good look at 1256 and decide whether it ought to align with the seatbelt secondary enforcement. Because as you know, there are 30 states that I can ride without the helmet or have a choice to do so. And one, I didn't want to let the occasion pass to let you know that I give tours of this building all the time. And at the end of the tour, I always point out the cannon on our front steps and tell them it's aimed right at the Commissioner of Motor Vehicles office. And they always get a laugh out of that for some reason. But Tony, I do hope you'll take a good hard look at that. I know the governor is actually sympathetic to that cause.
Well, we'll absolutely look at that, Senator.
You never miss
Are we
it.
all set?
Judge, are you with us?
12 years, Dick. I'm hoping that's the last gift I can get going out.
Well, if you become lieutenant governor, you'll be able to push it too. Judge Zone, do you have any thoughts on this proposal?
Sounds like a good way to go forward. I would support it.
Okay, good. Thank you. So Michelle, that's pretty, you cut out about half the wording. What is the date? What's the best day though? I think that would be the one thing. What gives you sufficient time, Commissioner, and both commissioners and Judge Zone and anybody else? What date would you like for the report? And do you want it by 2023 or 2024 or?
I'm going to defer to my colleagues at DMV as I haven't taken a comprehensive look at Title 23 in a couple of years.
Thank you, Commissioner. Having the opportunity to go further out than just a 6-month period is always beneficial because we can do thorough work. I must be completely honest, Senator, I didn't know 24 was an option, but to do the comprehensive, if that is something the committee would consider, we would absolutely support that. But if the committee wants a report or an update in January of 23, we could provide that. And I'm not trying to push the work out, but it is, Title 23 is very large and there's many different sections, as everyone knows, that we may be referencing one section, but there's impact someplace else. It's a comprehensive review and it's detailed. And I would prefer to allow my team and the team time to do good work, to bring back the recommendations that align with your intent.
How about a preliminary report, January of 23, which if there are things that become so obvious to you that they should be changed, you could provide that in the report and the legislature could make those changes next session. And then a final report, say July or even October of 23, which would put in motion for the 24 session to do it all. Would that be enough time?
Thank you. Yes, we will work with that. Thank you very much.
I like that incremental approach as well, Senator.
If you see something obvious, probably wouldn't be helmets, but something very obvious.
Okay, so is it January 15th?
From the Red Sox fan.
July what, 10? Yeah.
Okay, Michelle, is that easy enough?
In the next election.
Good. Is it January 15th and July 1, 23?
Yeah, I was thinking something like January, a date, which would, if they've identified a few of these offenses that should be changed or repealed or whatever. For example, it just said about a fine if you don't have your license. Maybe it shouldn't be a fine for that because they already have it electronically at the Department of Motor Vehicles. So whatever,
Senator Sears,
yeah.
when did you want the final report?
I was thinking July 1 of 20 or October 1 of 23.
Okay.
And the report would go to committees on the report would go to the named groups in B. Both reports.
Quite honestly, I'm not sure why it would I mean, government operations is happy to look at it, but this really is a judiciary issue and maybe a transportation issue.
Usually you're right. I don't know why government operations.
Because this has to do with fines and crimes and penalties and.
Yep.
I think it should go to judiciary and transportation.
I like that. Okay. Is that good for everybody?
Yep.
Okay, so we don't have to sunset the, I mean, it'll automatically,
No.
do we need to sunset it or do we just automatically it ends?
It ends.
It ends, it's not a, yeah,
It ends.
it ends.
Michelle, could you have that, a new draft by quarter of, so we could vote on it and get the bill out of here?
I can, it won't be edited by then, but I can give you a draft.
Except the, that's fine. We can find 5 or 10 minutes on Wednesday or Thursday.
So when does this committee get shut down?
Well, I'm hoping not until a week from Friday.
Okay, that's what I was thinking.
That's my hope. I had asked that of the pro tem's office and all I got back was it's a good plan, so.
So that's the 22nd, okay.
But I'd like to, you know, giving Commissioner Sherling and Commissioner Manoli time to speak with Hosanna, the executive director of the, would be a good thing to give her time in case she has some changes or doesn't.
Good idea.
Well, we could add in there or designate. It wouldn't necessarily have to be Susanna herself.
Oh, they want to check with her.
Right, to see it, but.
Yeah.
Yeah.
Before we.
For that, I mean, quite frankly, we already know that Commissioner Manoli will
Shove it off on Tony.
hand this over to a great extent to, you know, that, but I'm sure she'll okay the final draft.
Yeah.
Okay.
I think that's just kind of understood. I don't think the Commissioner of Public Safety is going to be the only one from public safety on this.
So Senator Sears, I'm gonna submit this morning to editing, and then when I get it back, I will send it to Peggy so she can send it out to the witnesses and the committee members, and then that way you guys can be ready to vote tomorrow.
Okay. Peggy, do we have 10 minutes tomorrow morning sometime? Let me look at my agenda.
We could do it at right before we put out ceiling.
Yeah, that sounds fine.
10:30 to 10:45, because we already have Michelle.
Yeah, and that's Michelle anyway, so that's good. Yeah. Shouldn't take more than 5 minutes, so just do 10:30 to 10:35 for a vote on the bill, and then we'll take up ceiling, and Michelle's going to be here anyway, so.
Hey, Tony, the selling point of 1256 is that there'd be a great deal of motorcyclists suddenly traveling within the speed limit if there's a secondary enforcement.
Oh.
All right, well, I'm going to, I mean, I realize it's only 11:30, but I really can't take up another bill without having it placed on the agenda. I don't think that would be fair to the public. So I hate to lose a half an hour of committee time, but I think.
Senator Sears,
Should we go offline?
could